The ERA, a debate between Phyllis Schlafly, National Chairman of Stop ERA, and Peg Anderson, Chairperson of the Iowa ERA Coalition.
Here is moderator Diane McCumber.
Welcome to the Iowa Manufacturers Association debate on the Equal Rights Amendment. We will begin with a 10-minute opening statement by each participant. They will then be asked to respond to specific questions that have been submitted to them in advance. We will close with 3-minute summary statements from each debater. As determined earlier by a flip of the coin, Peg Anderson will begin. Mrs. Anderson?
Thank you. I'm awfully glad to have this opportunity to visit with you this morning about an issue that is of very great importance to all the voters of Iowa in this election year of 1980. Because when we go to the polls in November to vote for president and senator and congressman and state legislators, we will also have the opportunity to vote on whether or not the state of Iowa shall amend its constitution to provide for equal treatment under the law for the men and women of Iowa. Now, I want to share with you a little secret this morning. My favorite feminist writer is not Betty Friedan or Gloria Steinem. My favorite feminist writer is Irma Bombeck. Anybody that has survived 4 teenagers all at one time and has successfully raised 4 children to productive adulthood knows what I mean when I say Irma Bombeck is my favorite writer. Well, Irma was in the state a couple of weeks ago, and she was speaking up for the Equal Rights Amendment, and at that time she said that the Equal Rights Amendment was the 24 most misunderstood words since one size fits all. I hope I hope this morning that I can clear up some of that misunderstanding and bring some clarity to this issue. We will be talking this morning about both the state and the federal Equal Rights Amendments, and what we will be voting on in November is the state Equal Rights Amendment. But the principle behind these issues is the same, and that is exactly what this is. It is a legal principle. It is the attempt to incorporate into the basic law of our land, the Constitution, the principle that men and women should be treated equally under the law. The Constitution and its amendments are a framework for our laws and a standard against which to judge governmental action. And just as the First Amendment tells the government not to interfere in the rights of freedom of religion or freedom of speech, so the Equal Rights Amendment tells the government not to deny or abridge rights on the basis of sex. It is a conservative statement in the most positive sense. It is a clear message to government to allow people to grow and function as individuals. It prohibits government from interfering in that basic right. The Equal Rights Amendment is a legal principle that limits the intrusion of government into our lives. And it is a legal principle. It is not a personal, does not have anything to do with personal and social relationships. How I relate to my husband in my marriage will not be affected by the Equal Rights Amendment. As a matter of fact, it would take more than an amendment to the Constitution to change that after 30 years of marriage. But it is important to remember that we will still have all of our own personal choices as women and as men as to whether we will work in the home or out the home or a combination of those things. The Equal Rights Amendment will not affect that in any way. This issue has a long history from the time the Equal Rights Amendment was first introduced into Congress in 1923. It was a direct outgrowth of that very courageous struggle of men and women to gain for us the right to vote, which was finally achieved with the 19th Amendment in 1920. By the way, if the 14th Amendment had covered women, there would have been no need for the 19th Amendment to get us the right to vote. And it's interesting to note that many of the same arguments were used during that struggle to get the right to vote. For some mystical reason, the right to vote was going to cause women to abandon their families and reject their wifely responsibilities. Well, for 72 years, those men and women fought against these unreasonable and unfounded arguments, and finally secured for us today that right which we take so for granted. It's in that same democratic tradition of securing basic rights for all citizens that Congress finally passed the Equal Rights Amendment in 1972. After many months of debate in both the judiciary committees of both houses, of a great deal of testimony in those committees and deliberations in the Congress, the vote was overwhelmingly in favor of the Equal Rights Amendment. In the House, the vote was 354 to 24, and in the Senate, it was a vote of 84 to 8. A very overwhelming majority, which, by the way, there was an overwhelming majority in Illinois just 2 weeks ago. That vote was 102 to 71. The problem is Illinois requires a 3/5 vote. Anyway, during the congressional debate, the Senate Majority Report and the statements made by the prevailing side in that debate became the legislative history of the Equal Rights Amendment, against which the courts will judge this issue. Any interpretations by people outside of the Congress and in the minority side do not have validity in terms of court decisions. Because of the recognized clear need for a clear and unambiguous statement of equality of rights under the law for men and women, most political leaders in this country have supported this issue for a long time. All of the last 7 presidents have supported it, dating all the way back to Eisenhower. Both political parties have supported it. It has been in the Republican platform, which it was in first, since 1940. And just yesterday, Governor Ray once again reaffirmed his strong support for the State Equal Rights Amendment in his press conference yesterday morning. The churches, most all of the mainline churches, have endorsed the Equal Rights Amendment. Methodists, Presbyterians, Episcopalians, etc., Lutherans, a large, long list of them. Many, many organizations, including the League of Women Voters, the American Association of University Women, Business and Professional Women. And last year, the American Bar Association has made the passage of the Equal Rights Amendment its top priority for the year. The Iowa Bar Association endorsed it a year ago. Recently, a Businessmen's Council for the Equal Rights Amendment has been formed with Coy Eklund, the president of Equitable Life Assurance, and William Agee, the chairman of the board of Bendix Corporation, as the co-chairman. Over 60% of the people in polls show that they do support the Equal Rights Amendment. These people know that this issue is clearly in the tradition of our democratic and Judeo-Christian values of concern for the individual and support for human rights. They also know that the arguments against the Equal Rights Amendment are demonstrably not true. And I say demonstrably because we can look at the states that already have an Equal Rights Amendment. And there are 6 states that have Equal Rights Amendments that are the same as the one being proposed for Iowa and the same as the federal Equal Rights Amendment. And those 6 states are Colorado, Pennsylvania, Maryland, Hawaii, New Mexico, and Washington. And I suggest to you that you all have friends and relatives, business acquaintances, business associates in those states. And you need only to check with those people in those states to know that the horror stories that have been put out about the Equal Rights Amendment just have not happened. Because the arguments against the Equal Rights Amendment have proved to be without merit, simply a smokescreen to hide, they prove to be just a smokescreen to hide the real reason why there is opposition to the Equal Rights Amendment. And that really is a lack of belief in a very basic value of this country. The real issue that we are dealing with here, both on the federal level and on the state level, is whether we do or do not believe that the Constitution of this country and of this state should clearly reflect the value that all citizens, whether male or female, should have equal treatment under the law. That is the question we will be voting on in November. And I believe that the voters of Iowa do believe in that value and will vote yes on November 4th. Thank you.
Thank you very much, Mrs. Anderson. Mrs. Schlafly, you have 10 minutes.
Just suppose your favorite football team were winning the game, and in the last quarter, the losing coach demanded that a fifth quarter be played to give them time to catch up, and furthermore demanded that in that extended time period, only the losing team would be permitted to carry the ball. Now, I live in a home of football fans, and I know that even the losing fans would not go for that kind of rules chicanery. It goes against every notion of fairness. Amending the United States Constitution is not a game. It is not just something so minor as a sport. It is the most serious sacred document of our land, and whatever rules of fairness ought to apply to games ought to apply 1,000 times over to the Constitution. The ERAers had their 7 years, which they were given in the original resolution. The average time for ratification of all constitutional amendments ever ratified is 1 year and 4 months. There has to be something the matter with one that can't make it in 7 years. But they got Congress to vote them an unfair, crooked time extension, only for states to switch from no to yes, but not for states to switch from yes to no. And then their plan is very simple. They want to use the power, the prestige, the money, and the pressure of the executive branch of the federal government to force states like Illinois to vote again and again and again until they switch from no to yes. At the same time that the Justice Department is in court trying to get a court to hold that states that ratified quickly have no right to switch from yes to no. This is the federal pressure that's in. And when we voted in Illinois about a week ago for the 15th time, the only reason they got as many votes as they did is because President Carter called 2 Chicago legislators and offered them a federal housing project for their districts if they would vote yes. We know that previously he has even threatened the cutoff of federal funds from the city of Chicago if they did not switch from no to yes. Jobs were offered, bribes were offered. This is the only way they got as many votes as they received. Even the Department of Energy some months ago put out a memorandum ordering a boycott of unratified states for Department of Energy meetings. This is the type of federal pressure we have been under in the unratified states, and still we're voting no. Why is it they want it? It's because of Section 2 of the Equal Rights Amendment, which gives the total enforcement power to the federal government. It would be the biggest grab for power, for federal power, in the history of our land. I, too, think Irma Bombeck is delightful. I think she's very funny. But when you need advice on a legal subject, you don't go to a comedian. And if she thinks that the Equal Rights Amendment only has 24 words, she doesn't even know about Section 2, which gives the total enforcement power to the federal government. Senator Sam Ervin said that Section 2 would give the federal government 70% of the powers that are still in state and local hands. It would give them power over all those areas of law which have traditionally made a difference of treatment on account of sex, such as marriage, divorce, adoptions, child custody, prison regulations, homosexual laws, and insurance rates. Why would anybody want to give the federal government all that new jurisdiction? They're having a dreadful time solving the problems of inflation, national defense, and the hostages, and they're not doing such a good job on that. Why would we want to give them that whole new grant of federal power? A grant of federal power that is larger than the Commerce Clause, larger than the Necessary and Proper Clause, or any other grant of power to the federal government. How do we know that would be the result? Because there are 7 other amendments to the Constitution which have that identical language. And there have been many Supreme Court decisions interpreting that very language. We know that under that language, it not only gives the power of enforcement to the federal government, but it also gives the power to preempt state laws. That is, even though your state laws may be constitutional, they can just substitute their federal judgment for your state judgment, and we don't need that. There's also Section 1 of the Equal Rights Amendment, which denies us our right ever again to make any reasonable differences of treatment between men and women. Now, ERA will not solve all your personal problems. It will not make your husband pay his child support payments. It will not make your husband do the diapers and the dishes. It will not get you a job and a promotion. What ERA will do is to make every law, federal and state, and every regulation and everything about the school system treat males and females the same. Now you have a perfect example of what that would do in the draft registration bill which has just been voted by the Congress. This draft registration bill calls for the draft registration of 19 and 20-year-old men, not women. The proposal to include women was defeated by an overwhelming vote in both houses of Congress. Now, aren't we lucky that we don't have the Equal Rights Amendment? Else that would have to apply to women, and women would have to be treated equally in registration, in the draft, and in combat, and in everything to do with the military, since the military is all a matter of federal law. I ask you to consider for a minute what President Carter's plan was. He proposed a sex-neutral draft registration plan, which would have taken our 19 and 20-year-old girls and boys, and it would have allowed all the tens of millions of men in this country, aged 21 and older, to avoid military duty while they send their younger sisters, their wives, and their daughters out to do their fighting for them. That is exactly what sex equality means. And during the hearings on this bill, the senator asked the president's witness and said, what if the 20-year-old woman is a mother with a 6-month-old baby and her number comes up on the lottery? And the answer was, she goes. That's sex equality. We do not believe in same treatment for men and women in the military. We do not believe in same treatment for wives and husbands, for mothers and fathers. This is utterly irrational, and obviously the American people don't want it. It's contrary to common sense, contrary to national defense, to the wishes of the overwhelming majority of the American people. Senator Sam Ervin proposed 2 separate qualifying clauses when ERA was going through the Congress. One would have exempted women from the draft, one from combat. And those were overwhelmingly rejected on roll call vote because the ERAers said they want sameness of treatment. That's not what the American people want, and that is why the ERA is being rejected across the country. Just remember what ERA will do. It will require every law to be sex neutral. That means you can never again have a law that says husband must support his wife. What's the matter with that law? It's a good law. It's society's answer to the fact that women have babies and men don't have babies, and there are differences. But it's sex discriminatory because a husband is a man. And we do not want a constitutional amendment to deprive us of our right to have such laws as that. ERA would also make it impossible to have any all-girls schools or all-boys schools or separate activities in the school system, because you all know under Supreme Court decisions that separate but equal is not equal. So everything that is touched by the law, by regulations of government, or by the school system would have to be fully sex integrated and would deprive us of our choices in all of those areas. ERA, beyond that, is a blank check to the federal courts. It asks the court to tell us what it means after it's ratified. You know, ERA does not put women in the Constitution. It doesn't mention women. It doesn't mention jobs. All it does is put sex in the Constitution. And sex is a word of a number of different meanings. ERA would be a blank check to the court to tell us what it means. No wonder the American Bar Association is for it. It would be a great day for lawyers. The litigation would be immense. And we would move into a system where we would have judicial legislation in all of these sensitive areas that are important to men and women. It would deny us our right to have differences, reasonable differences of treatment, even, say, in the insurance industry. It would take away the present right of young women to have lower automobile accident insurance rates and women to have lower life insurance rates. It would deprive us in many areas of our right to make reasonable, sensible differences of treatment between men and women. We think that's the only common sense way to approach life and law and schools and society, because there are fundamental differences and there are no exceptions in ERA. It would be a rigid, absolute mandate with total federal enforcement. Thank you.
Thank you very much, Mrs. Schlafly. Will you please now, at this section of the program, hold your applause until the end of the program. We have come to the portion of the debate where we will be addressing 6 specific issues. The first question is, what is the difference between the federal Equal Rights Amendment and the state Equal Rights Amendment as it will appear on the ballot in Iowa in November? Mrs. Schlafly, you have 2 minutes.
The state Equal Rights Amendment would not give you the effects of Section 2 of the federal ERA, nor would it govern federal law. But I agree with my opponent that the principle is the same, and the state ERA would have all the other effects of Section 1. In other words, it would forbid you to have any difference of treatment between men and women, no matter how reasonable. It would not even permit you to have any separations between men and women in anything that is touched by the government or any schools that have any government money. For example, you could never again have any all-girls schools or all-boys schools, or sex-separate activities on the school campuses, such as the basketball, the football, and so forth. We know this because of court decisions in the states that have state ERAs, where it has been specifically held in court decisions that girls must be admitted to the football and wrestling teams. You could never again have a law that says husband must support his wife. You could not have any sex used as a criterion in any of the insurance. Recent estimates showed that if you remove sex as a criterion, women's automobile accident rates will be increased by 29%. And furthermore, it would be a blank check to the courts for unlimited nonsense. Last week, a court in California under the Equal Rights Law held that a restaurant had to pay $18,000 to 2 men whom it had denied or whom it had required to put on neckties when they went into a restaurant. They said that was sex discriminatory because women were not required to wear neckties. In Pennsylvania, under the state ERA, the wives have lost their traditional rights. The Albert Einstein Medical Center versus Nathan said that in Pennsylvania, under the ERA, a husband cannot even be required to pay for his wife's hospital bill. The same thing has been true in Maryland and in other state ERA cases. ERA would be a blank check to the courts.
Thank you, Mrs. Schlafly. Mrs. Anderson, the question is, what is the difference between the federal Equal Rights Amendment and the state Equal Rights Amendment as it will appear on the ballot in Iowa in November?
The Iowa legislature ratified the federal Equal Rights Amendment in 1972. So the question of ratification of the federal Equal Rights Amendment is not an issue in Iowa. The question that we have before us is whether we shall amend our state constitution. As you notice, a great number of the arguments that have been used against the Equal Rights Amendment have to do with the federal government's encroachment upon the state's rights and other things that come strictly under the jurisdiction of the federal government. It's very important to point out that the question of the draft is simply not relevant to the Iowa Equal Rights Amendment question. We do not draft people in Iowa. Only those things that come under the jurisdiction of the state of Iowa would be affected. And the very things that have been said would be taken away by the federal actually come under the state Equal Rights Amendments, domestic law, those kinds of things. This is Iowa doing for its own people, providing a protection in the state for the people of Iowa, a guarantee for Iowa men and women that they shall have equal treatment under the law. It is a states' rights issue. And it is interesting that those who oppose the federal Equal Rights Amendment ought to be concerned about that, because that really is a primary, in some ways they say they are concerned about the states being able to handle those issues. But it is also interesting that here in Iowa, our leadership for promotion of the state Equal Rights Amendment has come entirely from Iowa people. We have prepared our own materials, and we have developed our own coalition. Both the state Republican and Democratic parties are members of that coalition. So regardless of what happens to the federal Equal Rights Amendment, if we pass the Iowa Equal Rights Amendment, we will be providing a very important protection for the citizens of Iowa in the terms of discrimination on the basis of sex.
Thank you, Mrs. Anderson. The second question will be addressed to Mrs. Anderson first, and it is, what will be the effect of the Equal Rights Amendment on the family? Mrs. Anderson?
Well, I care very much about the family. My family has been the center of my life for 30 years, and I have a very real concern about what the future holds for family life in this country. I think the Equal Rights Amendment ought to be called the Pro-Family Amendment. It is I think anything that contributes to fairness and justice in our society will contribute to a healthy family. A sense of respect for each individual as an individual, able to develop their own potential and develop their own God-given gifts, can only contribute to a healthy family. In specific terms, the Equal Rights Amendment will cause the recognition of the value of the work of the woman in the home. An extremely important principle in our society. We have given lip service to that for a long time, but we have never had a clear recognition of that very important principle, that the woman's work in the home does have an economic value. This is a very important principle because it would affect inheritance taxes, for instance, and estate taxes, especially here in Iowa, where our women in Iowa have contributed so much to the farm economy, to the development of agriculture and work besides their husband, and often had to pay inheritance tax on the whole property because they could not claim part ownership. Under an Equal Rights Amendment, that right would be guaranteed, that a woman that her work would be recognized and she could claim half ownership of the property. It's also important to remember that 1 out of 8 families in this country are headed by a woman alone. Those families need the protection of knowing that those women can compete equally with men in society to earn the money necessary to support those families.
Thank you, Mrs. Anderson. Mrs. Schlafly, the question again is, what will be the effect of the Equal Rights Amendment on the family?
If you are looking to the Equal Rights Amendment to lower taxes, make your husband respect you, make him send his support payments, or get you a husband, it won't do any of those things. What ERA does is to make the laws sex neutral. Several years ago at the Drake Law School, there was quite a study made of ERA, and the conclusion was that ERA would degrade the homemaker role and result in forcing wives out of the home to seek careers. Why? Because ERA makes it impossible to have a law or a rule that the husband must support his wife, because that is sex discriminatory. Now, we think those are good laws, but ERA makes them constitutionally impossible. That has been exactly what has happened in the states that have state ERAs. In Pennsylvania, there have been several cases. As I mentioned before, the Albert Einstein case held that the husband doesn't even have to pay for his wife's hospital bill. Coleman versus Maryland in Maryland decided the same thing. In Pennsylvania, the courts decided under the state ERA that the husband cannot be held for the primary financial responsibility of his minor children. But at the same time, in using the word sex, ERA would give homosexuals the right to get marriage licenses. ERA says you cannot deny or abridge any rights on account of sex. And if the city clerk denies a marriage license to 2 men, she is obviously denied a right on account of sex. So this one little word that sounds so simple, both at the same time takes away traditional rights of wives and gives them to homosexuals. It would also give rights for abortion funding. The powerful legal organization of the American Civil Liberties Union has already argued in a brief in court that the Equal Rights Amendment requires the payment of funds for abortion because to deny them would be sex discrimination under ERA. We don't need all this attack on the family that is involved in ERA.
Thank you, Mrs. Schlafly. The next question is, what would be the effect of the Equal Rights Amendment on employment and on equal pay for equal work? Mrs. Schlafly?
The biggest myth connected with the Equal Rights Amendment is that it has something to do with equal pay for equal work. It doesn't. Go back and read the language of it. It does not prohibit discrimination by private industry. It doesn't say anything about jobs. What it does is to prohibit discrimination by the United States or by any state. And so the only thing that ERA would do in the employment field is to make sure that the laws are sex equal. Now, the employment laws are already sex equal. We have the Equal Pay Act. We have the Equal Employment Opportunity Act of 1972, which prohibits discrimination in the job market on account of sex. And this applies to hiring, to pay, and to promotions. There's a whole federal bureau enforcing this. It's called the Equal Employment Opportunity Commission. And they're enforcing it so aggressively that they are even requiring businesses to give women the benefit of affirmative action. And there are many cases on record where they have required businesses to give the job to the less well-qualified woman in preference to the more qualified man in order to achieve their affirmative action quota. They have gotten enormous multi-million-dollar settlements against the biggest companies in our land. $38 million against AT&T, $30 million against the steel companies. Now, there may be some people who violate the law. I'm sure there will always be. But ERA doesn't have anything to do with enforcement. It's just like we have laws in every state against crime, and crimes still take place. Nobody says that if we put in a constitutional amendment against crime, that would solve the crime problem. You have to differentiate between the law and enforcement. The existing laws apply to all governmental entities. They apply to the private industry. They are very aggressively enforced, and ERA adds nothing to it. So if you think ERA has something to do with giving you a break in a job or promotion, you are chasing an illusion that cannot possibly come true.
Thank you, Mrs. Schlafly. Mrs. Anderson, the question is, what would be the effect of the Equal Rights Amendment on employment and on equal pay for equal work?
At the present time, only about 61% of the jobs in this country are covered by the Equal Pay Act. There are many government jobs that are not covered. The Equal Rights Amendment will affect those government jobs that are not now covered by the Equal Pay Act. Also, the Equal Rights Amendment, in regard to all of the laws, has a sense of reinforcing the principle that is behind those laws. It gives recognition to the fact that this society does mean, in fact, that we shall not differentiate and distinguish and discriminate on the basis of sex in the areas of jobs and employment and opportunity. It does not cause those laws to, it does not interfere in the private sector, that is correct. But it gives a psychological and philosophical basis for the other laws that are involved with the private sector. The equal pay and the other laws dealing in this area that are in the area of government would be reinforced by the Equal Rights Amendment. I think one of the things that we have to recognize in Iowa is that we do have many very fine laws in Iowa. We have had a progressive legislature in the last 4 to 8 years that have done a great deal about removing discrimination from our laws. But the Equal Rights Amendment will give a permanence to that. It will guarantee for the future the principles that have been passed in those laws now. Without an Equal Rights Amendment, there is no guarantee for our sons and daughters of the equality of rights that we want for them now.
Thank you, Mrs. Anderson. The next question is, how will the Equal Rights Amendment affect men? Mrs. Anderson?
I think that the Equal Rights Amendment is a very good thing for men, too. Again, I think that anything that increases fairness and justice is as important to men as it is for women. I also want to make very clear that I have a far greater respect for men than to think that they are currently supporting their wives and families only because of the law. If they are, we are in great jeopardy, because there is no law today, either in the United States or in the state of Iowa, that requires a husband to support his wife, because the courts will not interfere in an ongoing marriage. They will not enforce within an ongoing marriage any support from the husband. The husband has the total right to support his wife in the way he deems appropriate. We are most fortunate in this country, in this room today, and in this state and in this country, that most men have a very strong sense of love and affection and concern for their families. And the Equal Rights Amendment is not suddenly going to change that. Men also, the important thing about the Equal Rights Amendment is that it will give the courts the right in all kinds of cases to make the determination on the basis of the individual merits of the case, without prior assumptions about what the man is responsible for or the woman is responsible for. In many cases, this will work to the advantage of men who in the past, for instance, have not been able to gain child custody because of the assumption that the woman was the better custodial parent. That is just one kind of an example. The important thing is the sense of recognizing what the individual case requires, and what, in most cases of settlements for children, what is best for the child. That kind of fairness and justice in the long run is going to benefit men as much as women, and you should note very clearly that the Equal Rights Amendment does not say women any place in it. It says the government shall not deny or abridge rights on the basis of sex. It's a protection for both men and women.
Thank you, Mrs. Anderson. Mrs. Schlafly, how will the Equal Rights Amendment affect men?
It would be a grievous injustice to treat men and women the same when in fact they are different. Most women want to be treated like ladies, like wives, like mothers, not like men. And we are entitled to different treatments for husbands and wives, fathers and mothers. ERA would hurt men too, maybe not as much as it would hurt women, but it would hurt them because it would deny us our right to make reasonable differences of treatment. ERA would hurt men, of course, through Section 2 and the total federal control that it would bring. We would all suffer equally through the increased federal power grab. ERA would hurt men in the military. The biggest complaint we have in the military today is that the Army no longer discharges pregnant soldiers because they say that's sex discrimination. So they keep the pregnant service women on the job, give them a maternity uniform, and let them bring their babies back to the posts. Now, the men are doing the jobs for those women during those weeks of less than full capacity, and yet the women are getting the equal pay. Now, you just move this situation to a combat situation, and what do you have? Look at somebody like the great football player, Rocky Bleier, whose legs were shot up in Vietnam. The only reason he was alive was because his fellow soldier picked him up off the battlefield and carried him to a helicopter. Wasn't he lucky his fellow soldier wasn't a woman? Survival in the military situation depends on the strength and the stamina of your buddy, your fellow soldier. And the men who would really be hurt by ERA would be the ones who are sent out to battle with women by their side, out to face enemy troops, almost exclusively male, because you surely don't think the Russians are using female troops. Their army is 99.50% male. Thank you.
Thank you, Mrs. Schlafly. The next question is, what will be the effect of the Equal Rights Amendment on schools? Mrs. Schlafly?
The effect would be massive. First of all, it would bring the federal government even into private schools that get no public money. We know this because of the statement of the U.S. Civil Rights Commission that said ERA would get the government into schools even if they get no income tax exemption or public money of any kind. Beyond that, ERA would force all schools, public schools and universities, private schools that get public money, and private schools, to be fully sex integrated and to treat boys and girls exactly the same. We would lose our right to attend single-sex schools or colleges or sex-separate activities. Now, we were told that they wanted ERA because it would be permanent. That's the big defect. Look at what happened in education. Title IX was passed prohibiting discrimination on account of sex in the schools. And every year that the radicals in HEW tried to enforce this mandate, they found there's a minority of our people who like sex discrimination, and so Congress had to amend it every year. They exempted the right of people to attend single-sex schools and colleges. They had one amendment that took out fraternities and sororities and Girl Scouts and Boy Scouts. They had another one year to take out American Legion, Girls State and Boys State, and another one to take out mother-daughter, father-son school events, and to take out football and basketball and boxing and wrestling. These things are not immoral. They're not illegal under present law. But under ERA, they become unconstitutional because ERA would be part of the supreme law of the land. And if anything is clear, it is that it would immediately invalidate any part of any law that permits any sex discrimination or separation whatsoever. ERA would be federal control to force us into the unisex society.
Thank you, Mrs. Schlafly. Mrs. Anderson, what will be the effect of the Equal Rights Amendment on schools?
Well, I served on the Cedar Falls School Board for 6 years, and we were very concerned about the proliferation of different kinds of rules and regulations in regard to education. The Equal Rights Amendment will be a clear statement of the intent that there shall not be discrimination on the basis of sex in the schools. That is quite correct, and that deals only with the public schools. It is not correct that it would deal with private schools and make private schools single-sex. As a matter of fact, yesterday I called Jill Conway, the president of Smith College, who probably has the greatest interest of this, one of the persons with the most interest of anyone in the country. And as an alumna of that college, I knew that they had recently made a very careful study of the effects of the Equal Rights Amendment on the single-sex women's colleges. She assured me that their study and their lawyers' opinions very clearly stated that they did not expect the Equal Rights Amendment to jeopardize their continued position as a single-sex women's college. The Equal Rights Amendment does provide and would provide that there would not be discrimination in the schools, and it would help to enforce such things as Title IX and the equal opportunity, educational opportunity. I believe in that. I believe that my daughters ought to have the same opportunities in education as my sons. They did not, as a matter of fact. They were in school earlier than the enforcement of Title IX, and now young women in school are having all kinds of opportunities. It's important to remember we're talking about opportunities, not requirements for them to be involved in certain things. The effect of another interesting thing is that the anti-ERA forces are now supporting a bill called the Laxalt Family Bill, which would remove the enforcement provisions from Title IX and would undermine even that amount of equal opportunity in the schools that we have now. I certainly believe in our children having equal opportunity in our schools.
Thank you, Mrs. Anderson. Our last question, Mrs. Anderson, is what would be the effect of the Federal Equal Rights Amendment on military combat duty?
Well, first of all, I want to reiterate that the question of the draft and military combat duty does not have anything to do whatsoever with the State Equal Rights Amendment, which is what we will be deciding upon in November here in Iowa. Now, in relation to the Federal Equal Rights Amendment, Congress now has the power to draft women, and would draft women if it were necessary for the defense of our country in an emergency. Men and women would respond equally to the needs of the military. But if there was an Equal Rights Amendment, it is true that the draft law would have to treat men and women equally in terms of the actual draft. Now, I want to point out that there is still the right to make exemptions, as there always has been. And if you have twice the pool of possible draftees, you have half the chance that any person with a dependent would have to be drafted. The idea that mothers will be taken away from their children and wives and husbands separated to go off to the military is simply not true. Also, within the military, there are at the present time 95% of the jobs in the military today are being done by women. The remaining are what are called the combat positions. Only 1 out of 10 people are currently serving in any kind of combat position. The military commanders would still have the right to make the determination of who should serve in what unit based on their ability to carry out the function of that unit. It is totally a fair tactic to suggest that we are going to have large numbers of women being in combat units in the military of this country. And lastly, I want to point out that I have 2 sons and 2 daughters. I do not feel that my sons are expendable, that they have a greater responsibility, nor that they want to be dragged away from their careers any more than my daughters. I hope that none of them have to be drafted.
Thank you, Mrs. Anderson. Mrs. Schlafly, what would be the effect of the Federal Equal Rights Amendment on military combat duty?
There are 3 federal laws today which exempt women from combat duty, one for the Army, one for the Navy, and one for the Air Force. They are obviously sex discriminatory. If ERA goes into the Constitution, they get wiped out. Do you doubt that they want to do that? I sat through 4 days of hearings at the House Armed Services Committee last fall, and I saw the representatives of the Carter administration and the principal women's lib groups coming in saying, we want women in combat. We ask for the repeal of these laws. We want women to have their career opportunity to be in combat right along with men. Fortunately, the committee just buried their request because they know the American people don't want that. But ERA would require it. The House Judiciary Committee report on ERA said, and I quote, not only would women, including mothers, be subject to the draft, but the military would be compelled to place them in combat units alongside of men. The representatives of the administration have said they brag about all the combat-related jobs that women are put into now. Now, there's a small percentage of women who like that kind of a life, and they have their opportunity. They have all their choices to get the same pay and rank and join up. But most of us don't. My sons are all wrestlers. They've attended the Iowa Ames wrestling clinic. My daughters are not wrestlers. They want to be wives and mothers. Why should they be forced into this unisex mold just because these people want sameness of treatment for boys and girls? That's not what the American people want. And furthermore, the whole record of all history shows that you don't win wars and battles with female troops. If our daughters were taken into an administration which has already said they want to put women in combat, they would be subject to the sexual abuse that's going on in the Army today, to the lack of privacy, and they would be sent overseas to face enemy troops, almost exclusively male. This is one of the major reasons why we reject the Equal Rights Amendment.
Thank you, Mrs. Schlafly. We have an opportunity for a 3-minute summarization period from each of our speakers this morning. And Mrs. Schlafly will give the summary first of her opinions. Mrs. Schlafly?
When ERA was going through the Senate, Senator Ervin proposed 9 qualifying clauses that would have saved us from the nonsense of ERA. They were all defeated on a roll call vote. So the legislative history is just tremendous that ERA will have no exceptions. One clause said, except it won't require us to draft women. Another, except that it won't require us to put women in combat. Another, except that it won't take away the rights of wives, mothers, and widows. Another one, except it won't take away the rights of privacy. Another one, except that it won't take away laws that are based on physiological differences, which might have applied to laws about homosexuals and abortion. All of these qualifying languages were defeated because the ERA was wanted as rigid, absolute, total federal control. Therefore, if you oppose the Equal Rights Amendment for any reason, you need to oppose it altogether because there's no way to change it now. It cannot be amended. It is to be voted up or voted down, just exactly as it is, locked in concrete. Maybe you want homosexuals to get marriage licenses, but you don't want your daughters in combat. Then you have to vote no on ERA because there's no way to change it. Maybe you do want funding or abortions, but you don't want to eliminate girls' basketball. There's no way to change it. You've got to take the whole bag of a constitutional mandate for sameness of treatment in everything that's touched by the government, and you have no way to qualify it or to make reasonable exceptions. Now, there will be some areas where the proponents and the opponents will differ about what ERA will mean and what it will do. You know who will decide. It won't be the president of Smith College or my opponent or me. It will be the federal courts that will decide, or the state courts in regard to your state ERA. And ERA is very much a blank check to the courts to tell us what it means, to tell us whether this is reasonable, to tell us how we want our relationships between men and women ordered. This is not sensible to write this check to the courts to say, you decide all these sensitive issues for us. We don't want that. ERA would deny us our right to make reasonable differences of treatment between men and women that reasonable people want. And it would interfere in the schools, in family law, in the military. It would be a tremendous shift of power to the federal government. When ERA is put on the ballot in most states, it's overwhelmingly defeated. The last time it was on the ballot in Nevada, it was on the ballot in Florida, and it was overwhelmingly defeated by 2/3 of the voters. It was even defeated by 400,000 votes in the great state of New York. The American people don't want ERA, and we urge you to vote no.
Thank you, Mrs. Schlafly. Mrs. Anderson, you have an opportunity for a 3-minute summary.
Thank you. In conclusion, I would like to make 3 points. Equality of treatment under the law for men and women is as basic a right as freedom of speech or freedom of religion. We would not feel very comfortable if those basic rights were not protected in the Constitution and could be changed and were dependent upon the whims of any given legislature at any given time. We simply would not have the protection against the government interference if we did not have the First Amendment. The Equal Rights Amendment gives us a permanent guarantee of equality of rights and assures that the legislation that has equalized opportunities for boys and girls and men and women over the last few years will remain permanent and be there for our sons and daughters and their children. Secondly, the arguments against the Equal Rights Amendment have really proved to be untrue in those states that have an Equal Rights Amendment. In the state of Washington, the question of homosexual marriage was taken all the way to the Supreme Court. And in the case of Singer versus Hara, the court ruled very clearly that the Equal Rights Amendment did not validate homosexual marriage. When that is used as an argument, it is simply not true. The same thing is true with abortion. In all 6 of the states that have equal rights amendments, the rights to abortion have not been increased in any way. The question of abortion in the Supreme Court was decided on the right to privacy, not on discrimination charges. The cases that have been cited by the opponents to the Equal Rights Amendment are taken out of context, and they do not tell you the ultimate resolution of the case. As a matter of fact, one of the cases cited here today, Albert Einstein versus Nathan, is a county court case in Pennsylvania. We do not look to the county courts for the definitive interpretations of the Constitution. Again, the points up that the real reason that there is opposition to the Equal Rights Amendment is being against a very basic value of equality of rights for all the citizens of this country. Finally, the Constitution and its amendments are more than a legal document. They are a history of our life together as a people as we have searched for a just society and how to live together in a just society. And now in 1980, it is time that we complete that long search and together recognize our equality in that Constitution. Because despite all rhetoric to the contrary, there can be only one interpretation of opposition, that is not believing in equality. I believe the voters of Iowa do believe in equality of rights for men and women and will vote yes on November at the polls. Thank you.
Thank you, Mrs. Anderson. I want to thank Phyllis Schlafly and Peg Anderson for being on our program, and I want to thank you all for being here. This concludes our program.